Yields back, Ms. Spartz.
Thank you, Mr. Chairman. I'm actually kind of listening to all this discussion, very surprised how many loopholes our laws have, and very surprised to hear, our Constitution hasn't changed, thank God. But ultimately, what Mr. McClintock brought up, what's happening, it's really appalling to me. No wonder our citizens are not trusting its government, and it's very bad. I have a quick question, and I think Congressman Biggs brought another good question of rubber stamp, and I will yield him in a second because I would like to finish that conversation. But Professor Turley, just for you, what did allow for us to have these loopholes? Is it interpretation of the courts, or is really something in our legal framework that's so ambiguous that we need to clarify? What is allowed? Because it seems like this due process should exist regardless if we have a new technology, old technology, where we are. What happened?
Well, it was a perfect storm because you have the court that opened this up, creating a whole group of body of searches that can occur below the probable cause level with reasonable suspicion. That snowballed within a short time. They viewed those as narrow exceptions. It became the exception to swallow the rule. Then you had technology that poured into that gap. That is, it happened to be technology that fell in those areas. And suddenly, we're not protecting people, we're protecting places, or in this case, we're not protecting places like the cloud. So if you take stuff from one source to another, it's protected over here. The minute it goes to a cloud, which you have to use in many cases, or you use as a matter of course, it loses that protection. And I think your point is really the vital one. I think a lot of people be very surprised when they find out that their information is so readily available to the government. And that itself is a very corrupting aspect in a free society, that the public has a different view of what their privacy is from what the government is actively doing, not in a small number of cases, in massive numbers of cases.
Yeah, it sounds more like a surveillance state. We have to deal with that, but you believe it needs to have some legal actions from Congress to be able to remedy this situation.
This is not a particularly difficult problem to solve. It only takes will. You can easily create a framework that will protect privacy and fill this gap.
Okay, well, thank you very much, and I yield to Mr. Biggs.
I thank the gentlelady for yielding. And when we left off, when I ran out of time, Professor Turley just answered my question. I'll just remind you of what it is and give you the context. I was asking about the stick that might be necessary to help what we typically think of as an independent court. So you all seem to be in agreement with guidelines, et cetera, and statutory guidelines. How do you make sure that those are going to be tough enough?
If I may, I think...
Yeah, so Mr. Burton, then down the line, then Ms. Burton.
If I may, I think the concept of extending the Fourth Amendment to data that's stored in the cloud is a reasonable framework to consider here, because then that would take all of the existing sticks, as you put it, that would apply when government overreaches and violates Fourth Amendment rights, exclusion of evidence and so forth, and it would be applicable here as well. The irony is that Fourth Amendment jurisprudence is based on this notion of reasonable expectation of privacy. And in fact, your security and privacy of your data is higher in the cloud than it would be if you kept it in your premises or on your network at your corporation. So the technology is not, the law has not advanced with the technology to protect our citizens and our organizations' information.
Thank you.
And just to add to what my colleague here said, one of the reasons that media organizations are putting their data in the cloud is because they are also concerned about the security, and that they can't afford to have the kind of technologists and technologists in their shops who could protect from hacking and phishing and all of the other problems that we have with our data. So it puts them it puts many of the media companies in a really tricky position. But to the point about what kind of penalties you could have, there is the possibility perhaps of a 1983 action if rights were violated, and journalists have used that successfully in certain cases.
And Ms. Burton, before you answer this, I think we all would presume, at least I do anyway, that there's a private property interest. You have a private property right in your data, right? And thus it gets back, it begs the question that Mr. McClintock and Ms. Spartz were raising, and actually Ms. Lofgren. Why then do we have these loopholes? And then Professor Turley expounded on it. Why then do we have these loopholes that attack Fourth Amendment rights over your otherwise well-known and it should be established private property interest in your data?
Time has expired. The